Welcome back to Law News Network. I'm Heather Hansen, and that was just some of the testimony from Eric Hood, the victim in this case against the Morris brothers. Now, there were 5 defendants. 2 of them have taken plea deals, and there's another remaining defendant other than the Morris twins. We'll be seeing more of that case later on this afternoon. Right now, we have Stephen Mulroy, who is a former federal prosecutor and currently a criminal defense attorney, and we're fortunate enough to have him with us via Skype. Good morning, Stephen.
Good morning. Thanks for having me.
Thanks for being here with us. I want to talk to you first about the Morris brothers case. Now, you have been on both sides of criminal cases, I'm sure some like this. What do you think of the defense here that they were there, they were present, but they had nothing to do with this, and in fact, this is all just a shakedown for money? Do you think that that's going to fly with this jury?
Well, it's difficult to know what the jury is going to say. I do know that as a legal matter, mere presence at the scene of a crime is not by itself enough for liability. The jury would have to be convinced that the Morris brothers were actively participating in some way. They provided either directly engaged in the conduct or provided some material assistance to the others with the intent of helping them commit the crime. So, if the jury is convinced that they may have been there, but they didn't do anything, then that would be sufficient grounds for acquittal.
What do you think about the motive here? I think that the prosecutors are going to argue that the motive was there was some slight against the Morris brothers' mother made by Eric Hood. That motive, plus them being there at the crime, do you think that that's enough to tip it over so that the defense has a harder row to hoe?
I think the fact that there is that slight against the mother helps the prosecution significantly, because otherwise, what's the possible motivation for them to be involved and to risk their careers for this kind of thing? On the other hand, the fact that the defense theory is this is all a setup, this is all a shakedown, the person could have very easily sent that provocative text precisely as part of that shakedown, precisely to get some plausible reason for tying the Morris brothers to the crime. So, I think it's a jump ball there.
Yeah, that's an interesting theory, and it may be very well be played out here. I mean, we've seen the defense attorneys really go after each of the witnesses and really trying to establish this shakedown. It hadn't occurred to me, but you're right. They could certainly argue that this was all well planned out in advance, and in fact, the text was sent in order to establish a motive.
Right, exactly. I mean, if you're smart and prepared enough to go do this shakedown, then you might take that precaution as well.
Now, when you have a case involving well-known sports figures, whether they're local or in this case they're no longer local, how does that play into the way that you represent them? Do you try and sort of focus on it? Do you try to sort of let it be and just let the jury know it in the back of their minds? How do you play with that fact when you're putting together a strategy for your defense?
Well, when you've got well-known defendants as clients, typically the biggest interaction occurs during the jury selection process, when you're trying to screen out people that may have any kind of a bias against either those particular people or high-profile pro ball players to begin with. Once the trial occurs, I think for the most part it's just sort of part of the background information.
Yeah. In this case, though, it does come into play a little bit because they're the ones with the money. I think at one point, Eric Hood actually referred to the other one of the attackers as a peon because he did not have the same level of income as the Morris brothers did. So it's definitely one of those cases where it will sort of play into the defense, don't you think?
Oh yeah, I mean the disparity in money, that they are seen as the pots of gold, the deep pockets, and the other person not. I think that's relevant. Although, referring to anybody as a peon is never going to ingratiate yourself with any jury.
Yeah, definitely not. I think that's some interesting testimony that we'll be sure to play. I want to ask you, Stephen, if you were defending either one of the Morris brothers. Well, first of all, the fact that they have separate counsel, good move on their part?
Yes. Yes, if you can afford it to have separate counsel, I think is always the better thing to do. I mean, they presumably have a joint defense strategy, and that's fine, but you never know when the trial is going to develop in such a way that there may be divergent interests between the clients, and you don't want to have one lawyer representing 2 clients who have divergent interests. I mean, you know what's going to happen.
Well, and isn't the other interesting thing with that is you get multiple bites at the apple. So if I'm the first attorney to do the questioning and I forget to ask one of the key questions, the attorney next to me has the opportunity to make up for my error.
Oh, that's exactly right. And I've seen that happen in actual trials.
Yeah, it happens often. As long as all of the defendants are well unified, it can work very well, don't you think?
Yes, I agree. Hmm.
Now, in this case, we have two defendants who took plea deals. What do you think the chances are that one or both of them will testify in this case?
I don't know. I do know this, that it is likely that in order to get a better plea deal, one or more of them may have agreed to testify against the defendants, and that will be a condition of them getting the better plea deal. So, I wouldn't be at all surprised to see that happen.
Yeah, it's going to be interesting to see. Their sentencing isn't scheduled till October 16th, so it certainly gives some time for the prosecutors to see whether or not they're pleased with the testimony that comes out during this case. Now, in the same vein, would you expect either of the twins to testify?
That's always a touchy thing for a defense strategy. On the one hand, jurors would like to hear the defendant testify. They want to hear the juror tell the defendant tell his side of it. But at the same time, you open yourself up to cross-examination and all of that. Certainly, the more the defendant has a criminal history or anything embarrassing in their background which might come out under cross-examination, that would weigh against having the defendant testify. But I think generally, unless the prosecution's case is very, very weak and tenuous indeed, very often, you want to have the defendant take the stand because the juror wants to hear the defendant's side of it.
Right. I mean, in this case, I do have to say that thus far, the cross-examination of the witnesses has been very strong. And I know for myself, one of the sort of tendencies that I have is to prefer cross-examination over direct examination, because if you feel like you're winning on cross, why take that risk? Do you
Absolutely.
think that if by the end of the prosecutor's case, and arguably if those two defendants who took plea deals do testify, and if they do well with cross-examination there, do you think it would be risky to put the brothers on?
Yeah, I would agree with that. I think the default would be don't take the risk of putting the client on the stand unless at the end of the prosecution's case in chief, it seems a strong enough case that you have to. And if through effective cross-examination, you're able to sow enough doubt in the jurors' minds at the end of the prosecution's case in chief, then I think the smart move is the safe move, which is to not have your client testify.
Yeah, I think that that's probably the way to go. I do have a question. Given that you've been on both sides of cases like this one, why do you think there wasn't a plea deal here? Do you think it's solely because both of these gentlemen want to be able to play basketball?
Yeah, I think these defendants are uniquely in a position of having a lot to lose if they have any kind of a conviction, especially for a felony. So I think that because they have a lot to lose, they're less incentivized to just say, oh, well, I'll minimize the risk and go ahead and take the conviction. They're going for broke because they have so much to lose.
I want to shift gears on you, Stephen, for just a little bit and talk about the Alito case, because I know our viewers just love Dalia Alito, and it's a case that just keeps on giving gifts to us here at LawNewz because they have constant hearings. Now, today's hearing, I want to be clear because I think a lot of the people in the audience are unsure, and understandably so. We've had so many Alito hearings. But this hearing today is specifically about an issue with the attorney. And it's not Brian Claypool, but it's rather Greg Rosenfeld, who's one of the defense attorneys. And it sort of comes down to these facts. The defense wanted to put on a Dr. Walker to speak about battered women syndrome or battered spouse syndrome. And the prosecutor argued that that's fine, but if they do, then we should be able to be allowed to have our expert examine Dalia. They hired someone named Dr. Alexander. Mr. Rosenfeld, the attorney for Dalia, agreed to that, and it didn't agree, it was ordered, it was court ordered. And they were making arrangements for Dalia to come in. She didn't want to come in on a weekday because she felt that she would have some anxiety and she had childcare issues. They made arrangements for the doctor to see Dalia on the weekend. The doctor agreed, and then Mr. Rosenfeld just didn't bring her in. Didn't bring her in on Saturday as was scheduled, and then there were some emails between them on Saturday night, and then he didn't bring her in again on Sunday. Now the prosecution is moving for sanctions. First, I want to ask you just, what do you think the chances are of some sanctions given those facts?
I think the judge is likely to be a little bit impatient that the attorneys aren't able to work these kinds of things out on their own. I think that, if it's seen as a willful refusal on the part of the defense counsel to obey a court order, then sanctions could flow. That's contempt of court. But this sounds to me more like just a scheduling problem. The person didn't show, but if the person shows up and says, "Sorry, Your Honor, there were some things that came up, but we are going to make ourselves available soon," then I think the judge is not likely to go the route of actually imposing sanctions, which is kind of drastic, and just give a stern warning to defense counsel: work it out, go do what you said you're going to do. I don't want to have to deal with this issue again.
Yeah, I mean, it's usually consecutive behavior like this that is constant that really lends itself to judges doing monetary sanctions, isn't it?
Well, it's either going to be a repeated pattern of failure to meet deadlines or to do what you said you were going to do or to obey the court's order, or circumstances which show that it was willful as opposed to negligent. A deliberate refusal to obey the court's order could, with even just one instance, lead to sanctions. But for something like this, I'm sure the defense counsel is just going to say, well, there were things that came up, we did our best, but we promise we'll get to the next meeting. And as long as you do that, I don't think the sanctions are going to flow unless, as you say, that happens over and over and over again.
You made a really good point there, Stephen, and it's something that I think that we see often. As lawyers, you become such strong advocates that sometimes you can't sort of see the forest for the trees, and there's a lot of arguing between lawyers. And don't you think sometimes judges feel like parents who get tired of people telling on each other and just say, go work it out on your own?
Yes, and I've seen judges do that all the time. They lose patience and they say, this is not a good use of the court's time. You are all adults and professionals. You should be able to work these things out on your own. And, regardless of who's right or who's wrong, the judge can end up getting frustrated with both lawyers for wasting the court's time. Just like, as you say, with the parent, the parent will say at some point, I don't care who started it. I want you both to stop.
And whenever that happens to me, I feel like that child. It's not fair, Your Honor. It's not fair. He's not being fair. But you're right. I mean, I think the judges see so much of that, and they would much prefer to see you be adults and professionals and work things out amongst them yourselves. So we'll see what happens today at the hearing that's scheduled for about 1 o'clock this afternoon, I think. I'll double check on that time. Stephen, I wanted to thank you so much for being here with us. We certainly appreciate it. As we continue to watch this Morris case, I'm sure we'll have you back to comment on it some more.
Well, I appreciate that, and I do teach criminal law at the University of Memphis Law School, and I think this kind of stuff will be useful for the students as well.
You know what, Stephen, before I let you go then, I do want to ask you a question because it came up in the chat room, and I don't want to put you on the spot, so if you don't know the answer, please let me know. But one of the things the chatters were asking about the Holly Bobo case that just finished in Tennessee is that the jurors were allowed to bring their notes home, their notes from the trial. Now, I have never seen that. Do you know, is that something that's allowed in some areas in Tennessee? Are you aware of that?
Actually, I've not heard of that happening, so I'm afraid I'm not going to be able to provide much insight on that one.
Well, maybe the fact that you haven't heard of it is a little bit of insight, because I have never heard of it. I've practiced and watched trials in a number of jurisdictions, and it's always been a pretty strict sign that the jurors are to destroy those. It doesn't just get taken away, but ultimately destroyed. So it's an interesting issue that we might see on appeal. But again, thank you so much, Stephen, for being with us, and I'm sure that we'll see you again soon.
Thank you very much.